Alors, bonjour à tous et à toutes. J'ouvre maintenant la séance. Bienvenue à la réunion numéro 62.
Welcome to meeting number 62 of our committee, and good Monday to one and all. It's a pleasure to see you, and according to our order of reference, we are looking at C-288, amendment of an act on telecommunications. So today's meeting is a hybrid meeting according to the order of reference offered to us in June. We have people with us on video conference, Mr. Reza Rajabian. My excuses if I mispronounce your name. He's here as an individual, as an expert in telecommunication strategy. Thank you for being here. We also have the Commission for Complaints for Telecom Television Services, Howard Maker, the Commissioner, Chief Executive Officer, José Thibault, Assistant Commissioner, and finally, Open Knight, Eric Knight, Senior Campaigner. So we thank all our witnesses for being here today, and without any further ado, I'm going to give the floor to Mr. Rajabian for 5 minutes.
Monsieur Rajabian,
Mr. Rajabian, you're on mute, I believe.
Yes. Okay. Thank you and good afternoon. My name is Reza Rajabian. I'm a researcher and consultant in the area of competition and telecom policy. My research explores how the design of telecommunication policies and strategic behavior of network providers shape the evolution of internet connectivity that people experience within Canada and internationally. In my consulting practice, I have served organizations such as the Ontario Ministry of Infrastructure and the CRTC as subject matter experts on broadband policy issues. I have also represented rural municipalities and consumer advocacy groups before the CRTC and assisted communities across Canada to identify private broadband service gaps and devise strategies for improvement. I appear before you in my personal capacity as an individual. My views do not reflect those of any organizations which have been affiliated. I will briefly provide some background on the underlying economic problem that motivates this bill, what I see as its weakness, and offer some suggestions for potential amendments. Firstly, the basic problem the bill is trying to address is a common one. The market convention has been to specify broadband speeds in terms of a maximum theoretical up to X megabits per second and use best effort retail contracts. However, actual internet speeds and reliability vary widely, which negatively affects the user experience and access to vital services and applications. Telecom regulatory authorities in other advanced economies have developed policies that aim to address the same problem as this bill. In addition to examples from Australia, UK, and US discussed previously by the bill's sponsor, I note that the transparency and retail contract regulations regarding both minimum and normal typical internet speeds are key elements of the European Union's open internet regulations adopted back in 2015. This bill does not go as far as the European Union regulatory framework in terms of strengthening quality commitments in standard form retail contracts. Nevertheless, what the bill proposes to do is broadly consistent with trends in other jurisdictions trying to address the same fundamental quality signaling problems in broadband service markets. Secondly, in terms of regulatory history, it's relevant to note that concerns about gaps between advertised and actual speeds certain providers deliver have come before the CRTC for at least a decade in my recollection. The CRTC has, however, been reluctant to take on the issue. Notably, in the development of the CRTC's 2019 Internet Code, the CRTC explicitly excluded advertised speeds and service quality issues from the scope of the discussions in the proceeding. CRTC did not provide reasons for doing so. As such, the bill will help mitigate what can be viewed as an error in developing the Internet Code a few years back. More broadly, unanimous support in the House for this bill has the potential to enhance the incentives of the CRTC to prioritize competition and consumer interests in its future policies. Third, I would like to note that in practice, gaps between service speeds providers advertise and those they deliver depend, among other factors, on how much particular providers invest in network capacity as demand grows over time. In relatively high-income urban centers of Canada, private sector incentives to increase capacity and deliver higher speeds tend to be relatively strong. In these areas, some providers may, in fact, be delivering speeds that they promise, as suggested by CRTC's broadband test data. However, on the edges of wireline, cable, and fiber networks outside of urban centers, where network investment incentives are relatively weak, the problem tends to be more pervasive and undermines the business case for rural fiber deployments by reducing expected take-up rates. In this context, the bill has the potential to promote incentives of service providers to invest in reliable, high-speed broadband technologies, make sure providers keep up with growing demand, and enhance digital equity. In summary, if implemented in an effective manner by the CRTC, the bill has the potential to achieve its stated objectives of better informing consumers and promoting competition. However, the bill does not go far enough in terms of enforcement, contractual accountability of suppliers, and remedies for consumers who end up not receiving what they are paying for. I would advise that the committee recommends additional language that makes suppliers more accountable for the quality and reliability of services they deliver to their customers, potentially via reforms to the Internet Code. Thank you for the opportunity to appear, and I look forward to answering questions the committee may have.
Merci beaucoup, Monsieur Rajabian.
Thank you very much, Mr. Rabajian. Now we are going to hear from the Commission for Complaints for Telecom TV Services. Mr. Howard, the floor is yours. Mr. Maker, pardon me.
Thank you. Thank you, Mr. Chair. I'm Howard Maker, Commissioner and CEO of CCTS, the Commission for Complaints for Telecom Television Services. And with me today is my colleague, José Thibault, our Assistant Commissioner of Operations and Business Services. CCTS is Canada's national organization providing free service to consumers to help them resolve complaints about retail, internet, wireless, TV, and local phone services under a structure and mandate approved by the CRTC, thus ensuring that our governance and operations are independent of the industry. In simpler terms, we're the industry ombudsman, and we have dealt with over 150,000 complaints since inception. We deal with complaints about billing, service quality, adherence to contracts, and credit management. We're here to ensure that service providers meet their contractual obligations to their consumer and small business customers. And we have an enviable track record for assisting Canadian customers, facilitating the resolution of nearly 90% of all complaints, often within 30 days. Indeed, we have the authority to require our 400 plus participating service providers to fix customer problems and to compensate customers where appropriate. Our decisions are binding on those providers. We also report on what drives consumer complaints, regularly publishing aggregated data about the issues we see to ensure that consumers, the industry, and the regulator are fully informed about the issues that cause complaints and to drive positive change in the industry. In addition, we administer the CRTC's 4 consumer codes of conduct, which we use as benchmarks for service provider conduct when investigating complaints. José?
Internet is the second most complained about service, and complaints about insufficient internet speeds fall within our mandate. We track these speed complaints under a category we call quality of service, which is a basket of issues that includes complaints about slow internet speeds, as well as other service issues like service outages. Quality of service is the most frequently raised problem by internet customers, accounting for about 17% of all internet problems raised last year. In a recent audit, we found that complaints specifically about internet speed accounted for about 25% of all of the quality of service concerns raised by internet customers. In these complaints, customers told us they weren't getting the speeds they thought they contracted for, or that they didn't understand that the speeds displayed in their plans were the maximum speeds that might be made available to them. And in most of these complaints, we also found that the provider actually offered a lower tiered plan that may have better suited the customer considering the actual speeds available to them. Now, CCTS's mandate is to determine whether the service provider met its contractual obligations to the customer. So when investigating a complaint, we review the provider's obligations to the customer, which are contained in their terms of service, their policies, the customer's contract, and the CRTC codes of conduct. We note the CRTC codes do not contain any obligations on speeds or performance, and that currently there's no requirement for service providers to include any speed metrics in customer contracts. When investigating a complaint, we also consider what disclosure was made to the customer about speed guarantees and performance expectations when they subscribe to the service. And if we find a discrepancy between expected and actual speeds, we look at whether the customer is on the best plan for their needs. So for example, if a customer is on a 100 megabits per second plan, but is only getting 25 megabits per second, we'll examine the service provider's tier of plans and propose a more appropriate plan in light of the actual speeds the customer is receiving and require the provider to reimburse the customer for the difference between the two plans. Howard?
With regard to C288, we've said publicly regularly that being fully informed is really the best protection that a consumer can have. Now, CCTS is not a policy-making or a regulatory body, nor do we advocate for either industry or consumer interests. But given the number of internet service quality complaints that we see, it seems reasonable to conclude that making service metrics available to customers when they subscribe to internet service would be a step forward in ensuring that they understand what they're getting and in achieving our objective of full disclosure. In our work, we regularly see complaints that arise when customers think they're buying something but wind up getting something different. Disclosure of service metrics may very well help avoid this. For these reasons, you can appreciate why Bill C-288 is of interest to us, and we thank you for the opportunity to appear before you to discuss it. Of course, we're happy to answer any questions that you may have about our work.
Thank you very much, and I'll now turn to Madame Knight for 5 minutes.
Thank you. Good afternoon. My name is Erin Knight. Today I'm calling in from New York City, which is the traditional homeland of Lenape. Thank you for the chance to speak today on behalf of the open media community comprising nearly 300,000 people in Canada. Open Media is a nonpartisan grassroots organization that works to keep the internet open, affordable, and surveillance-free. It's my sincerest pleasure to be here today in full support of Bill C-288. Open Media was very pleased to see all the parties come together to advance this bill to the committee stage because, let's be clear, Bill C-288 is not a controversial piece of legislation. We can all agree that it serves to empower everyday people, support their right to high-quality connectivity, and protect them from shady business practices by big telecom. Improvements to the status quo that will benefit every person in this room and people in Canada writ large. That said, I'm happy to share some of the specific reasons why parliamentarians on all sides should be eager to pass this bill. Let me begin by sharing an important stat. According to a September 2022 survey for Global Live, people in Canada view our telecom sector more negatively than any other industry. And it's really no wonder. Talk to the average Canadian and they'll tell you that big telecom is very good at squeezing customers, not only on pricing, but on the value received for services purchased. And I'm referring, of course, to advertised internet download speeds versus the actual speeds customers receive on average. Over the years, members of the open media community have raised with us concerning discrepancies between the two. In general, the problem goes something like this. ISPs might advertise a certain speed for a particular plan. A customer subscribes to that plan believing that's the speed that they're paying for, only to discover that their connection is far slower than that during the times when they actually need to use it. And this is because the service agreement says their plan only goes up to the advertised speed, but no promises. Information that's not plainly shared with customers, but instead hidden in the fine print. To illustrate, let me take a moment to share the experiences of Angela, who is a low-income member of the open media community, in their own words. Quote, 2.5 years ago, I signed up for Internet 600 with Shaw. I have never once received the actual internet speed I was paying for. It has always been artificially capped at around 300 or sometimes 200 megabits per second. Trying to upgrade to the newer, faster option would carry a bigger price tag with no guarantee or even any reason to believe they would actually deliver on the improved service. The prices are always going up, the service is unreliable and falsely advertised. These problems have existed across the board with all the big internet companies, end quote. C288 tackles this issue clearly and concisely. When you sign up for an internet plan, you deserve to know what you're paying for before you pay, and this legislation will make it so. At the end of the day, it's about truth and transparency. If an internet provider is advertising certain speeds, consumers have the right to know before they buy if those speeds accurately reflect average performance. And there's a fundamental reason why we need this to come in legislative form rather than rely totally on the regulator. So let's first make clear the difference between the new CRTC policy direction and Bill C288 and how the direction needs to work in tandem with legislation like this if we hope to see any of the protections we're discussing today be implemented. The policy direction tells the CRTC how to interpret cases in front of them in a way that promotes competition, affordability, and the consumer interest. It's a framework that will apply only to future CRTC regulatory decisions moving forward. The direction can only help the Commission interpret what is in front of them. There's no CRTC proceeding explicitly taking place right now related to broadband speed advertising, so there's nothing on the topic for the Commission to apply the policy direction to. Without the application component, we will not see this issue move forward at the CRTC. C288 is that legislative application. The bill directly mandates the CRTC to hold public hearings on this issue, and that means the bill would immediately put the broadband speed advertising item in front of the Commission, giving the CRTC the opportunity to actually apply the policy direction framework. In closing, I'd like to remind us all where Bill C288 sits in the wider scope of the transformative changes that we need to urgently make in telecom in Canada. And if I can be frank, this is the lowest hanging fruit. If we can't do this simple, uncontroversial, pro-consumer move that other countries have already done, then I am deeply concerned about our ability as a country to make the changes that we so desperately need. Thanks, and I look forward to your questions.
Thank you very much for your testimonies. We'll now open the discussion with Mr. Williams for 6 minutes.
Thank you very much, Mr. Chair, and thank you to our witnesses for joining online today this very important discussion. Ms. Knight, thank you for being here. We share your values, the open, affordable, surveillance-free internet, which is very, very important. When we talked about this bill, and thank you, I know you've summarized some of the direction to the CRTC, and this seems to be one of the major points, perhaps, of dissension between the groups. We talked about this bill a few weeks ago, and some members suggested that Minister Champagne's February 13th announcement on policy to the CRTC made this bill unnecessary. So I know you've already touched upon this, but do you agree with that sentiment?
I'm happy to reiterate that the new CRTC policy direction on its own will not address the broadband speed advertising issue at hand that we're discussing. As a regulatory framework, the policy direction doesn't go far enough without a corresponding legislative application, which this bill in particular will provide. And that's why C288, in my opinion, is complementary to the policy direction and not contradictory to it. And all the more reason why C288 is not controversial.
Thank you. And just to also reiterate, is Minister Champagne's policy directive binding on the CRTC? So without this bill, does the CRTC have to act on his recommendations?
The CRTC has to use the policy direction as a framework when it makes its decisions based on cases that are in front of it. So that's why I mentioned in my testimony that putting those cases in front of the CRTC are going to be really, really key to making sure that there is actually an enforceability element to the policy direction as is. Because that was one of the major concerns that Open Media had with the policy direction was how actually is this going to be implemented and how is this actually going to affect Canadians day to day? This legislative application is a really great example of how we can apply that enforceability mechanism.
Great. And just to reiterate then, does it make it more important that we pass this bill to make the CRT direction binding?
Absolutely.
Thank you. As remote working and schooling looks to remain a permanent piece of society, and we certainly saw it during COVID-19, do rural internet speeds being less than advertised and often inadequate for online video streaming deny rural Canadians equality or opportunity?
Sorry, is that a question for me?
Yes, sorry. all
no
these to Ms. Knight, yes.
No problem. Yes. Rural and remote households are absolutely affected the most, or anyone who relies on low-cost internet services, but in particular, rural and remote households. For most of us, high-speed internet underperformance is going to be irritating, and it's still a huge problem. But when lower speed internet, like you would get in a rural community, underperforms, it's effectively denying people an essential service. So it's a difference between getting a 75 megabits per second average speed on a plan that's advertised as 100 versus if you're in a rural community getting 2 megabits per second on a plan advertised as 15. The latter is something that actually stops you from using the internet effectively in 2023. And so I really need to stress that ensuring transparent and accurate broadband services is non-negotiable to closing the digital divide in rural and remote Canada.
I did want to touch into that, and that segues into competition. And we have, certainly in the last year or so, we've seen bigger telecommunication companies buying up smaller providers. One of the only independent wholesalers left is Tech Savvy. We've had them to this committee before. What does a reduction in competition mean for rural and remote internet customers?
For anyone in Canada, the reduction of competition is a huge, huge problem. And we are seeing right now an extinction event for independent internet service providers. And that really goes back to the dysfunction happening right now in the wholesale access system, as you've mentioned. Wholesale high-speed access rates are clearly inflated, and the wholesale fiber to the home access system has not been functionally implemented to date. So that dysfunction is causing the mass extinction of independent internet providers. And that in itself is preventing meaningful reduction in retail internet pricing for all Canadians, including rural and remote customers. And that also has implications for network build out as well. So Open Media is really pleased to see that the CRTC is looking at reviewing wholesale, but it does remain to be seen what the CRTC does with that. And we hope that they will choose to side with Canadians and not side with big telecom yet again.
And in the recent announcement of 10% reduction in certain, well, again, policy decision or plan to reduce the wholesale rates by 10%, is that enough to help a few remaining smaller local ISPs compete?
I can't speak to if that number itself is enough. We have heard from independent ISPs that immediate relief was really critical, and so we are happy that that immediate relief did come. I will wait to see what the CRTC does with its review. Open Media will no doubt bring forward the opinions of our close to 300,000 community members and that of Canadians who have a stake in this issue.
And in terms of helping new ISPs get off the ground, do you have any recommendations of how we help more smaller companies compete?
Well, firstly, we do know that ISED is looking at reforming the Competition Act. And so there are a number of things that they could do to lessen the force that monopoly powers play in our economy. And reducing the clout of monopoly powers in Canada is certainly going to improve things for smaller companies. And then in itself, the wholesale access review, as I mentioned, is a critical part of paving the way for smaller companies to enter into the Canadian market and also thrive in the Canadian market, because right now those conditions are causing those companies to be unsustainable.
Thank you very much.
Merci beaucoup.
Thank you.
Monsieur Erskine Smith, la parole est à vous.
Mr. Erskine Smith, you have the floor.
Thanks, Joel. I want to start with Open Media and Ms. Knight. And first, just to say thanks for the advocacy. I look forward to a bigger conversation around privacy reforms when it comes to our committee, and which will be, in many ways, a more substantive conversation. This bill is important nonetheless, and it's a short bill, and there's not a ton to it other than a requirement to really formalize the direction to the CRTC right now, which is a good thing, formalizing it through legislation, I think, ultimately. Are there any amendments that you would like to see to the legislation as it is?
So we did hear from some other folks in talking about this bill that there are possibilities to strengthen the bill to empower consumers. We would be happy with any sort of strengthening, further strengthening that would empower consumers and protect consumers from being abused by big telecom in the ways that they are, in the ways that we hear or have heard from them for decades. I don't have a specific thing that I would like to see in this bill, but if there were something that would improve the ability of consumers to, as I believe Riza mentioned, achieve recourse for issues that they're having with this discrepancy in speed advertising, absolutely, we would be happy to support things that empower consumers.
Interesting. And I don't know, Reza, if you want to pick up from there. On my read of the bill, it's a pretty straightforward requirement for transparency, and it doesn't get into remedial measures in any way whatsoever. So it would be a little bit different if we were to amend the bill with a measure like that. But what did you have anything in mind in terms of how we might go about strengthening this, or is it straightforward, just pass the thing and on to the next thing?
Well, the transparency part is a good step forward. What I was trying to highlight is that there is another aspect to this, and I think the CCTS can probably expand on it. All the contracts, retail contracts, say your speeds may vary. So they're not really, so there is no guarantee, there's no binding commitment from the supplier. So for example, right now somebody's trying to put together a class action lawsuit in Manitoba around broadband speeds not being delivered in rural areas. But that contract element, I'm not sure if they're going to get certified, because the contract, essentially the standard form contract, allows the supplier to deliver whatever they want. And what I was trying to point out is that this is a step forward, but it's not as strong as, for example, European Union regulations, which are trying to specify concrete performance measurements in retail contracts.
Does anyone else want to weigh?
Goes to this, sorry.
I appreciate that. Does Ms. Thibault or Mr. Maker, do you want to weigh in on what's just been expressed in terms of strengthening, if not in this bill, but strengthening a regime overall in terms of, demanding not only transparency but some accountability to consumers?
Well, I'll follow on Mr. Rajabun's comment, which took the words out of my mouth pretty much. I think from our perspective, we are an organization that looks at the commitment and the contractual responsibilities that service providers have to customers. And so I think you've done the right thing in this bill in terms of providing the authority to the CRTC to do all the detail work and to decide what metrics should be made available and so forth. And I think what we would add to that is, if we come to that proceeding, which we would, is that we would like to see those metrics as part of the contract so that they become in some way enforceable, and so we can look at them and say, okay, now we know exactly what the service provider has offered to provide, and we know what the consumer has agreed to accept.
I will say, as a consumer, I have never in my life done a speed test that has ever met the stated speed, that whether upload or download, that I'm paying for. Have any of you ever done the speed test and hit that amount that is listed and advertised?
That's a bit challenging, sir. In fact, and I know I'm not here to speak personally, but you did ask a personal question, and so the answer is I've done that lots of times because I'm always curious. And I had a recent experience, so I'm on a 150 megabeeps package, and in the past I have exceeded the 150, but I was dealing with my own ISP, and I had one of their reps in my office right here, and I said, let's go to one of these speed test sites. We did that, and depending on which server we connected to, one of them said I was getting 130, and another one said I was getting 80, and so I don't know what an average consumer is supposed to do with that. And particularly, so if I have an up to 150, my service provider has met its commitment. They've given me up to 150, whether it's 80 or 130. And that's, I think, that's the problem with the up to advertising.
Understood. And so I take the view that from all of the witnesses, it sounds like that, and if anyone disagrees, please be heard, but that this is a bill that should be passed. It's a bill that does strengthen the transparency regime for consumers. We could strengthen the accountability mechanisms. We could look to the EU potentially for doing so. But as it stands, this is something we should pass as is and get the CRTC to do its work. Is that speak now or forever hold your peace? Okay, perfect. Thanks so much. Oh, we've got one. Okay, Mr. Maker.
I was going to jump in. I was just going to say there is an accountability mechanism now. It's CCTS. So I just thought I should point that out because the problem is, do we have enough tools with which to apply the accountability? That's the question, and that's what I think this bill would help us with.
Gotcha. All right, thanks so much.
Merci beaucoup, Monsieur Lemire.
Merci.
Thank you very much for the witnesses for their contribution to this study, which is going to be very important. In rural and remote areas, Mr. Rajathiam, you spoke of service to outside of municipal areas. I'd like to hear more from you on the issue. Is it because the investments don't allow us to attain those speeds, or is it impossible to do so in these remote regions? And so these kind of plans should not even be offered to our rural subscribers.
The plans that are offered to rural subscribers tend to have lower speeds because of the technological differences. The issue, as you noted, is about the weakness of investment incentives. So today, somebody deploys a new network and they may be able to deliver that 50-10 to the population in a small town or something. But as demand grows over time, that capacity will start getting constrained. The difference between a small town and a more competitive urban core is that the incentives to reinvest in capacity is limited. So this is one of the problems you see with the rural broadband programs that were adopted about 10, 15 years ago on the fixed wireless, is that they didn't really account for that demand growth. So lots of public subsidies went out 10, 15 years ago to develop these rural wireless networks, but there was no accounting for demand growth. Like some provinces, even were saying we have solved the rural connectivity problem. But then COVID hit, and sort of the fact that the emperor has no clothes exposed itself. And one problem, I've been working on a lot of rural broadband projects across the country, and reviewing both development and reviewing them. And one problem you see with the rural fiber deployments is that a new fiber provider, to invest, they need it's already hard enough to justify, and you get some subsidies from upper tier governments, hopefully. The problem is when you're competing against lower speed services that advertise higher speeds, that reduce your expected take-up rate as an investor in that project. So you're undermining essentially rural fiber deployments that are networks that can deliver promises speeds they deliver. So reduce, and that's what I mean by that signaling problem, the lemons problem. So when the quality is not, consumers cannot really assess the quality, there's uncertainty about the quality, that undermines the incentives of a higher quality network and investors to come into the market because they can't signal the quality of their new products as well as they should and get as much revenue that they need to sustain the business. So that's why I was trying to emphasize the particular importance of this bill, if implemented properly by CRTC for rural areas, remote communities, and also for some urban centers that are sort of low-income urban centers where their incentives to invest is not that much. So people are still relying on old legacy copper networks, and if you cannot justify the revenue from the business case on these processes, you essentially, even if you get all the subsidies to deploy the network over time, the revenue you will not be reinvesting in the network as demand grows, and so we're going to see this problem. So this is not a short-term. I think this bill it can be a long-term solution for improving accountability and efficiency of the markets.
Merci beaucoup. Effectivement, que c'est très...
Well, effectively, it's very rare to see companies that will voluntarily invest themselves because it's harder to be profitable. This is why governments have to invest and incite, either through directives to the CRTC or offering direct incentives to the industry. Are we going far enough in the requirements we seek from network providers to offer a quality service and technical equipment, update of these materials and technologies in order to be sure and secure for the users? How far should we go to get quality service?
we're talking right now about maximum speeds and advertised speeds. But another angle on all this is minimum service quality standards. And this has been in front of the CRTC for many years, and they actually adopted, they had many proceedings, and they adopted a minimum service quality standard and also how to measure it. So the measurement questions Mr. Maker was coming up with, there is a methodology that CRTC has developed, but this was never implemented in practice. So for example, all the rural subsidy programs, and I advocated that when you give out subsidies, put in a minimum service quality standards that are legally binding in the subsidy contracts. But as far as I know, nobody has really done that. So essentially, subsidies are going out, and there's going to be monitoring of that it's built, but nobody's going to be looking at what the quality of service is going to be in a few years. So that adoption of minimum standards in contracts. So what the EU is doing, they on the contractual side. So you have to have the normal or typical speed plus minimum speed specified in the contract, and then different regulators have different ways of measuring it. I was just looking at what the Dutch regulator is doing on this. So they have definitions. So you're not getting the normal speed that you were promised if 8 out of 10 tests over a week do not meet that threshold. So this can be specified. And then if those standards are not met, the consumer can go to CCTS or join a class action lawsuit. So there are very practical ways of dealing with this. But the minimums are very important. Sorry.
Tout à fait. Merci beaucoup.
Thank you very much.
We will now turn to Mr. Massey for 6 minutes.
Thank you, Mr. Chair, and thank you for our witnesses here today. It's kind of become almost like predicting the weather in terms of internet speeds and services. And, you know, it's almost like a daily or hourly excursion for people. And it's also become a cottage industry for some businesses on this. But what we're looking at here is not necessarily really whether we can change that at the moment through this legislation. What we're looking at is accountable practices for advertising and sucking in consumers for almost false advertising in many respects. And so I think my first question will be to Ms. Knight, looking for amendments that you might have or suggestions on penalties or repercussions for those that are, you know, there'll be good actors, hopefully, that will be able to, you know, meet practical, you know, and predictable ways of going about a responsible way. But there might be still those that, you know, in the past used to be able to write off fines and penalties as a business-related expense. It's one of the things that we were able to get changed here because it was a loss leader for the company. So it was, you know, part of doing business. And that's what I worry about a bit with the legislation is having some good actors come in, but then others that will continue to do misleading practices because it'll just be the cost of doing business.
Sorry, I missed the mute button. Yeah, when it comes to misleading practices, I think we're already seeing that today, and I really can only see it improving with this legislation. I don't see this legislation doing anything that would make anything worse. I think looking to, when you're talking about penalties and such, looking to the other examples in other countries, there's probably a good bet. And I think like other witnesses on the panel today would be able to speak to that a bit more than I can. But, you know, I've been looking at the broadband labeling that the FCC has introduced. If you're a consumer, you'd be looking at that label to see things like typical download speed, typical upload speed, and latency. And I think all that information available up front is really critical, as you mentioned. And I don't want to get away from that at all. I want to make sure that it's clear to everyone that we are talking about just making information transparent to people. And that's actually fairly uncontroversial. When it comes to penalties for big telecom, presently, I don't think there exists a good penalty for them. I think that penalties could be significantly improved in many, many ways. When we talk about enforceability mechanisms, it does include going past that cost of doing business. What about it is actually going to deter companies from behaving in shady ways to their customers? I hope to see the CRTC look at this in terms of the misleading sales practices aspect that came to them and then left and nothing really happened with it. I hope to see more happen on that. And, in particular, we've seen some folks advocating for private right of action for telecom consumers, so the right to do telecom class action lawsuits. That is something that could help as well. But in terms of amendments to this particular bill, I don't have any for you in this regard.
Okay, fair enough. And I want to move to Mr. Maker. One of the things that I worked on before was microbeads. And banning microbeads was supported by the industry and environmental defense. We got them together and we got 90% agreement on banning microbeads because there was then, at that time, a number of different players that wanted to actually get to better practices, but they were being undercut, again, by some bad actors in the process. In your complaints that you get and the ones that you're able to resolve, do you have like a couple bad actors? Is it universal in terms of the problems that you deal with? Or is it disproportionate to a couple of organizations in particular? Kind of give us a little snapshot of what you get there, because if we were able to get the industry on board as well too, because this is to be a helpful process for everybody at the end of the day in consumer accountability, it would be far stronger. And that's kind of really where we ended up. We ended up with the Union of the Environmental and actually the Chemical Producers Plastics Association and getting unanimous, conjecture in the House of Commons and finally a vote that was lived up to. So what are you getting and how is it so reflective of the broader industry?
Well, I'm going to try and answer what I think are a few questions wrapped up into one there, if I may. What I always say is that, we have over 400 participating service providers across the country, and we resolve almost 90% of customer complaints. And so I think that by itself is an indication that once something comes to us, we get pretty good cooperation from the industry. Otherwise, we'd have a much lower resolution rate. In terms of, which companies are generating complaints, we publish all of that data regularly. And so it's all in the public domain. And Jose may have some more detailed stats at her fingertips, but, the large providers, I think the top 5 or is the top 10, Jose, account for about 80% of the complaints. So it often, it's pretty typical to vary by size of service provider. I'm sorry, I hope that answered your question.
Yeah, and I think the only thing I would add to that is in terms of the volume that we see, when we look at last calendar year, there was over 1,200 complaints about the quality of internet service. And that's a fairly significant number, given that in order to get to us, customers are generally at their last stage of trying to get something fixed. And, we really represent the end stage of complaints for them. So it's a fairly significant number. And, CCTS has been around for 15 years, and both myself and Mr. Maker have been around for pretty much the entirety of that time. And I can say I don't think I've ever come across any situation where we haven't felt that service providers can always do better to make sure that customers understand what they're getting, what's included in their service, what the limitations are, and that disclosure of information is really key to ensuring a good consumer experience.
Thank you. I think I'm running out of time, but I mean, it would be nice if we, I think Ms. Knight said it best. If we can't do this, then we really can't do anything. I mean, quite frankly, this is a good piece of legislation that should be universal across all political parties and the House and so forth. And, but it's a start for public accountability, I think. And if we can't get the industry on side from this, then it's just a fist fight all the way through. Thank you, Mr. Chair.
Thank you very much, Mr. Massé. Mr. Perkins, the floor is yours.
Thank you, Mr. Chair, and thank you, witnesses. And I'm going to do a little prop thing again, of course, because there are hopefully people out there watching and want to understand exactly what it is that we're talking about. We're talking about the marketing initially that's done by the internet service providers. You can go to their websites and see what that marketing is on what you're buying. So Mr. Maker mentioned that he buys 150, I think it is, megabytes per second package, and going through a server, which means it's probably got some sort of boost. It's done through business or whatever. But but not getting 150. And in fact, at Bell, the 150 costs $110 a month, and the next step down, the 50 costs $90. So it is possible that a consumer, I believe, is paying for much more than they get. So, Mr. Maker, I just wanted to confirm with you that that's not your personal case, but that's what you see, is that people are basically paying for a level up or two and actually getting a level down of service when they actually look at their performance.
Well, as Ms. Thibault mentioned in our opening comments, that's right. We do often see that. And we try to adjust. We try to take care of that mismatch by sort of re-rating the plan as if the customer had been on the proper plan from the get-go. So yeah, the issue is people are not getting, in many cases, the speeds that they thought they were getting, not understanding that what they bought was the maximum quote.
And that's just a small percentage of consumers that actually check their speed. I think most people probably pay their speed, pay the bill every month. I think the telecommunications companies have some of these sales practices where you buy a phone for a 2-year package at X rate, and after 2 years when you've paid for the phone, for some reason, they don't automatically reduce your cell phone bill because you've already paid for the phone. If you continue to keep the phone, they keep charging you at the same rate. Shouldn't it be, Mr. Maker or the other witnesses, that automatically the internet service providers are monitoring the service that you're getting, and if you're paying too much, that they're required by law to actually automatically reduce what you're being charged a month?
I'm sorry, I'm not sure.
Dr. Rajabian, if I pronounce your name correctly, I hope.
Technically and theoretically, you could develop a system that does that. But I think practically that could be very complex. Can you hear me?
Yeah, I thank you for that. If I could continue with a question for you. In your Lemons paper in 2015, you mentioned that you didn't think it was possible to set minimum speeds. But if I understood you correctly to the questioning earlier, I think by Mr. Erskine-Smith, you actually do believe that you can set minimum performance standards now. Is that correct?
Yes, I'm sorry. I'm not sure if that was mentioned in that 2015 paper, but it was a while back. So yes, definitely. Minimum service quality standards are they are being implemented in various countries, and CRTC already has, to some extent, worked on this issue in the committee, in their technical committees. So they have a good understanding of what it could be, but they just haven't implemented it.
So I have a question on that, but first, before I ask that question, could you table as a document later, if you have one that shows in the various countries that we can have as evidence, things that other countries and what they're doing on that?
I can, that requires a research project to actually write it separate ones, but I can direct you to the European Commission's. That is a big research project to go through different countries and put it together. But I can direct you to the European Commission regulations, Article 4(1)(d) and E.
Thank you. I'm running out of time, so I just want to ask one more question of Ms. Knight. Ms. Knight, given that this is clearly going on and most Canadians are oblivious to this, do you think this is intentional false advertising by these companies?
I see it like this. So if you talk to a telecom company, I'm sure they will tell you that they believe that they are giving you the service quality that you're paying for. And many of them will say that to you if you talk to them. But in my opinion, if there's nothing wrong with their average network performance according to a telecom company, then they really have nothing to fear from a bill that makes that network performance data transparent and publicly available. Because in that case, customers win. Like, customers win in either direction. Then in that case, they'd be getting good quality service and empowering information. And then in the other direction, if it turns out that it's true that people are not getting what they pay for, then customers win in that scenario as well. They get more information about what they're paying for, and there's more onus on the telecom companies to actually deliver the services that they're advertising.
Oh, I still got 30 seconds. Okay. one more question. Do we have either Ms. Knight or any of the other witnesses any idea of the percentage of Canadians that actually understand or know the speed that they're getting? Ms. Knight, is there any research out there that shows Canadians are actually knowledgeable about what they're getting?
I'll
or
let
not?
Riza take this one.
Over the past few years, there has been a lot of progress in this area, especially in rural areas. Lots of internet testing because the official data about access, that you said this many people have access, this percentage of population to 50, 10 megabits per second packages that you see in the universal service base, those are all based on advertised speeds. And areas that are not, that advertised speeds are higher than that benchmark, they are not eligible for funding. So what a lot of rural communities have been doing is to do their own speed tests, community testing, using different platforms to better understand it. So there has been quite a bit of progress on that. And you say people know when they're not getting the speeds they're paying for. It's not, so it's nothing is a problem as long as it's working. But so it's everybody has knowledge of when they're not getting what they're paying for.
Thank you very much. Mr. Dung, the floor is yours.
Thank you, Chair. I'm really happy that the witnesses coming forward give us their insight on, especially with the CCTS. So my question, I will start with Ms. Thibault and Mr. Maker. My experience as a provincial member, in Ontario, there's something called Tarion, where developers or builders will have, it's an insurance program, they're mandatory to enter. So if a building falls flat and the consumer or the owner can take it to Tarion. And what happens is that that will affect their sort of insurance rate for the next year. So usually builders will rush to fix the problem, whether it's a door, whether it's a sink or drain or whatever, so they can avoid further escalation to Tarion. Now, the reason why I'm bringing this up is that I see the CCTS in its original establishment. It was created so it's independent, industry funded. Sort of a resolution center for consumers. But what's the incentive for providers to join and fund you, knowing that you're going to be a watchdog over their shoulder? I just tried to learn a bit more about CCTS.
Mr. Dong, the answer to your question is that service providers are required by the CRTC to participate in CCTS. So they join because they are required to, and some of them, it's true to say, we do have to kind of drag them on board a little bit, but it is a regulatory requirement. And the other incentive, I suppose, is we in our experience, we've found that particularly the larger service providers, are very, very concerned about the numbers that we report publicly in terms of who had how many complaints filed by their customers with CCTS. They're very sensitive to that, so there's a disincentive to not resolving those problems. And certainly there's a financial disincentive because part of the funding formula requires them to pay for each customer complaint that comes to us.
Oh, I see. Oh, that makes sense, because then the providers that have the most problem, that you spend most resource on, will have to pay more to cover.
That's right. That's right. And they need a team of staff to work on those complaints as well.
Right. And this bill C-288 will require Canadian carriers to make easily available certain information in respect of fixed broadband service that they offer. So, which means that those information are now, right now, are not available to consumers. So if that's the case, how do you resolve a case? Like, how do you prove to the providers that you haven't delivered what you promised?
Jose, do you want to respond to that one?
Sure. So when we're handling a complaint, we're going to look at a number of things. And one of the main things we're going to look at is what was the customer advised when they agreed to take the service? And we do that by looking at terms of service, contracts, those sorts of things. And then we require the provider to engage in troubleshooting, technical tests if they haven't already done so, to do it, sometimes to do it again, and to submit to us the results of those tests. And so we can see and compare what a customer was expecting to get and what they're actually getting. And if there's a difference between those two things, then we can make that right for consumers and require the provider to reimburse them, say, for the cost difference. We also have the authority to issue additional compensation to the customer. So that's generally how we approach these things. And this is also why in our comments we mentioned that, having speed information directly in contracts is a useful tool for an organization like CCTS as well, because it makes it clearer in terms of what the customer is supposed to get.
That's great. And how does this bill potentially can help, if passed, can help your work? Would it make your work easier in terms of getting a resolution?
Yeah, well, again, I think it makes it clearer in terms of what the customer could expect. So absolutely, that makes our job easier. I would also suggest, though, that and I'm not saying anything new. We've been saying this for many years, that providing that information at the point of sale, so before a customer agrees to the contract, is key. And generally for consumers, that is the ideal situation. But for consumers that find themselves faced with, a bill or a service speed situation that they didn't anticipate, having speed information or any other parameters of what was promised to them, clearly indicated in their agreements, is absolutely helpful for us to help resolve those complaints.
Well, I'm very supportive of the spirit of this bill, but I'm also at the same time surprised that there isn't a regulatory framework that allows you to just kind of use regulations, whether it's CCTS or CRTC, just to make those requirements.
There is a regulatory framework. Yeah, if I may, there is a regulatory framework. The Parliament has already provided a regulatory framework, and CRTC has the authority to do this, but they have not done it. So, for example, in 2019, when they were adopting the Internet Code, they explicitly excluded what this bill is trying to do. So they didn't even consider it. They have the authority, but they have been unwilling to do it. So that's... And that's
but if bill passes, would that be any, in terms of legislation, would there be any a conflict between the regulatory power and legislative power, in your view?
No, you're essentially complementing and giving direction, democratic accountability over one element of the regulatory authority that you have provided to the CRTC, but the CRTC has forborne from applying its authority for some reason or another. We don't know.
Thank you.
Merci beaucoup, Monsieur Lemire.
Mr. Lemire. Yes, thank you, Chair. And Ms. Knight, I'd like to hear you on the issue of the various recommendations. One possible pathway to a solution would be to make them more normative, the regulations or the conditions, that they don't offer the service for which people have paid. There should be some kind of sanction, perhaps reimbursement to the consumer, or an obligation to actually provide what they have promised.
Table when it comes to giving recourse to consumers or giving empowerment in that sense to consumers. I don't think that I am in the position to tell the CRTC what they should be doing with this case that comes in front of them. But I can say that I really think it's important for this legislation to put this item in front of the CRTC so that they can do their job and they can figure that part out. That said, yes, there can be absolutely many mechanisms of enforcement that improve things for consumers and that put money back in consumers' pockets. Because at the end of the day, this is an affordability issue.
À votre connaissance,
And to your knowledge, I think we can agree that they do have the capacity to obtain the information about provided speeds. The consumer is not necessarily aware of what he's really getting, what he's paying for. Would it be important for the provider to be more transparent so that ultimately they would provide the information and perhaps the rates would be adapted to what they are really providing?
I think like transparency could have a really positive effect on pricing when it comes to, the lack of affordability that we see both in, we're talking about broadband, but, if we're talking about telecom in general, people paying some of the highest prices in the world still to this day in Canada on cell phone and internet prices both. So yes, the more transparent information can be made available to consumers, this is a positive step for competition. If we're asking providers to compete on actual speeds and actual service quality, yeah, absolutely. Like this is great for innovation. This is great for competition. I will say that, in all the other respects that our parliamentarians should be looking at improving competition, that would this is one part of that greater conversation. I won't say that it solves the entire competition problem, but yes, it absolutely would have a positive effect.
merci beaucoup.
Thank you very much.
Merci, Monsieur Lemire.
Thank you, Mr. Lemire. Mr. Massé, you have the floor.
Thank you, Mr. Chair. Mr. Rajabiun, you had it correct with the CRTC, and I don't think it's a coincidence the minister has finally written a letter that's a little bit more pro-consumer than ever before. I mean, I just did a quick search of my CRTC press releases, and it's full of all kinds of contradictions that they've done in the past, including even slowing down the protection of fraud robocalls, where they gave extensions from, basically a known process that could have protected Canadians consumers from fraud. So this is just basically, at the end of the day, as you're saying, just cementing best practices in model, and we don't have to wait around on bended knee for either the minister or something else from the CRTC to shake out what people should get from purchasing something with their own money.
Yeah, on the question of the fraud calls, I'm sorry, this is tangent, but I just want to sort of correct you on that. One of the problems with implementation of those anti-fraud systems is the false positives that it create, all of them. So it's true that they can stop certain fraudulent calls, but one has to be very careful about not blocking legitimate communications. And so that is a technical issue, and the telcos and the technology wasn't ready, and the telcos weren't really ready for it. So beside that, the question of the new policy direction that we see with very good words about consumers and competition, it's important to recognize that this is the second policy direction that this government has issued. And the first one actually did the exact opposite thing. So it was essentially trying to roll back a lot of the progress that had been made in trying to create a more competitive environment at the CRTC regulations between 2012 and 2016. The government essentially issued a policy direction which forced the regulator to reverse course, and now it's reversing course again. So that is a key problem with giving policy directions to an independent regulator. You're creating this dynamic inconsistency in the policy. In my view, the act that the parliament has set out is very clear about its objectives, promoting affordability, quality of service, and universal access. Some of the problem with these policy directions is that it actually tries to at one point the industry puts a lot of pressure on the government, and the government tells the CRTC with the direction not to do too much. So one has to be very careful not to get away from the legislative framework that you have set out already.
Right.
And that is the key, I think.
Essentially, though, if you want this done, do it this way and it's done. And if not, then we wait around for whenever from the CRTC and, just see what happens.
Well, maybe there'll be a cultural change. There was a cultural change that was happening at the CRTC for a few years, but then it was reversed. unfortunately.
yeah.
And that's why we
I've-
end up with the highest prices in the world.
I've been here during the Maxime Bernier years and before that, so I can go on and.
Okay,
Thank you, Mr. Chair.
and that is the Maxime Bernier's policy direction was the start of this process. And then the previous government, by the end of their term, they realized that that was a mistake and they tried to reverse course. So.
Thank you very much. I'll now turn to Mr. Viss.
Well, thank you, Mr. Chair, and thank you to our witnesses for a very comprehensive meeting thus far. In advance of Bill C-288 coming before our committee, a number of the telecommunication companies wrote to my office and stated that MP Mazier's bill is unnecessary and, in their view, unworkable. They cited two key reasons. One being their commitments under the wireless code and the need to provide with customers in a way that is clear, timely, and accurate, and to use plain language. That's under the wireless code. And the second reason they gave was the internet code, and that under the internet code, a service provider must communicate with customers in a way that is clear, easy to understand, timely, accurate, and accessible, and that uses plain language. Again, they also cited some rules under the Competition Act about deceptive advertising, and they outlined that the CRTC has conducted 2 studies about wireline internet speeds, and the findings by an independent company have found that wireline ISPs generally provide the speeds they advertise. I guess I'll go to Aaron first. Aaron, would you agree? I'm not going to outline which companies wrote this to me, but would you agree in general that, well, what do you think of the comments I just made? I'll just leave it there.
I feel like I have a great idea of who wrote that to you. Okay, let me say, I am not in the business of taking big telecoms talking points at face value. So let me be clear about that. I can say that it's obvious why these monopolized companies don't want a bill that would reveal to customers that average speeds might not live up to the package that they were sold. Either customers will want to downgrade to cheaper plans, or they would have to more accurately reflect the actual service speed that they're receiving, and both of those things would interfere with big telecom's ability to unfairly profit off of Canadians. But
that's very helpful. Let me interject right there. So, according to your expertise, the wireless code and the internet code are not sufficient to do what this bill is seeking to do.
Absolutely not. Without question, current legislation is not sufficient and it's not working. I would say that Big Telecom has some flagrant disobedience and exploitation of loopholes, and that's been carefully documented by the CRTC, the federal government, civil society. It's obvious that we need clear, precise, and enforceable requirements to hold these companies accountable, and that's not presently happening.
Okay, I'll just turn that question over to Mr. Rajabian. Do you believe that the wireless code and the internet code and the current regulations are sufficient to ensure that customers know what they're getting?
This bill has nothing to do with the wireless services. So that's sort of just the point of obfuscation. This is about fixed networks. And as you've heard, as I explained, and from Mr. Maker, the internet code does not incorporate any elements against misleading advertising or service quality levels. And as I mentioned, CRTC explicitly excluded putting those in the internet code, so they're not in there. So yes, those 2 points, the first one about wireless is tangential, not related to this bill, and the second one is factually incorrect.
Thank you. Changing course here, Mr. Maker, you mentioned some of the statistics and the ability of the commission to deal with complaints put forward by customers across Canada. I live in an area and represent a riding that has major problems accessing internet as a basic service. So I'm just curious, on behalf of my constituents, what percentage of your complaints came from rural Canada and what percentage came from urban Canada? Secondly, what was your percentage rate on solving the issues in rural Canada versus the issues you were able to deal with in urban Canada?
I'm not sure that we have any specific data on that. I know we've done a quick look at some of the stats after receiving your invitation to appear here. Jose, do you have any line of sight into that?
Yeah, on the first point, unfortunately, I can't really talk about the resolution rate for rural Canadians versus urban Canadians, but I do have some information in terms of just the proportion of complaints that come from rural Canadians versus urban Canadians. And when we take a look at all complaint types, so not just internet service issues, but all internet, all wireless, all home phone, the proportion of complaints that are coming from rural Canadians is about 10%. But when you zero in on internet quality of service issues, that jumps up to 20%. So there's definitely a disproportionate number coming from rural Canadians.
That's very helpful. Mr. Chair, how much time do I have remaining?
You can go a little longer if you want, but you're out of time.
2 hours.
I think I'm good. Thank you.
Okay. Thank you. MP Gahir, 5 minutes.
Thank you, Chair, and thank you to all the witnesses for their contributions to the committee thus far. My first question is for CCTS. So what recourse do consumers currently have if the speeds that are being provided to them don't match expectations? Just the whole gambit of what can they do?
Well, the first thing that we encourage them to do is to contact their service provider and see what the problem is and whether it can be sorted out. And most of the providers have troubleshooting policies and tools that they apply to make sure that they're delivering the best service that they can in the circumstances to that particular customer. If they are unable to sort out, they're not unable to give the customer what the customer believes they're entitled to, the customer is welcome to file a complaint with CCTS, and we'll examine it based on the information that's available to us related to that particular complaint. That's how it would work within our process. And as you've heard previously from Ms. Thibault, she described the process for how we look at those complaints and how we process them.
Okay, perfect.
And I'd say,
no, please go ahead.
Just going to say, on a practical level, in terms of your question about what specific recourse we can offer consumers, it looks like getting to the bottom of what the issue is. It looks like crediting any overage charges. So, I think I gave an example in our opening remarks that if a customer is on a plan for 100 megabits per second and they're getting 25 and the provider actually offers an up to 50 plan, we would look at the difference between those costs and we would require the service provider to compensate the difference of those costs. And we could also provide additional compensation for up to $5,000 to consumers above and beyond that crediting of the billed amount.
Great, thank you. My next question is for Ms. Knight. You had mentioned similar approaches that were taken in other countries. So how does Bill C-288 compare to similar initiatives put in place by other countries? And could it be stronger in what ways?
Yeah, good question. I think I'll answer a little bit of that and maybe throw that to one of the other panelists who maybe have a little bit more background on it. But I can mention that the FCC's broadband labeling approach, which, as I mentioned, when you go subscribe to an internet plan in the US, it would have things like typical download speed, typical upload speed, typical latency, things that are not presently on advertising materials in Canada if you were to subscribe to an internet plan. That's the same type of thing that this bill is talking about. It's talking about making that network performance data available to the consumer at that point of sale, as a CCTS has mentioned. So it does follow that. I am in favor of that. I think it's a great approach. And we want to make sure that people are empowered, like I said, at that point of sale. So if there's someone who wants to jump in and talk more specifically about some other examples, feel free, but that's what I have to share.
Nope, doesn't look like anyone else will take you up on that. So my next question is generally open for the panel. So this bill would require the CRTC to hold public hearings to determine how service quality and other metrics that internet service would be required to publicly provide. What kind of metrics would you like to see come out of those hearings? Anyone?
Well, you have speeds, and I think that's the point that we should also mention the reliability of services has become more important. So speeds are important, that bandwidth, but things like latency and jitter, these technical terms that enable video streaming. So the US, they're adding latency. And also given, if you remember Rogers' big outage a few months back, another element that could be added, and it's usually exists in some business contracts, is sort of that service being operational continuously. So you can have some minimum thresholds for service being out, but some compensatory mechanism and information about commitments to keeping the service up can be useful. So, but and for example, in a lot of in retail business contracts, you could insert certain markets in Canada. You could get a contract that the supplier, the service provider, guarantees a minimum service quality objectives for you. Objective for you, but you can't do that in the retail residential market or outside of urban cores. So these are sort of aspects of the contract and the signaling between buyers and sellers that could be put in there, but the more information you put in there, the more confusing it gets. So you need to stick with some key performance indicators, which are up and down speeds and latency.
Great, thank you.
Merci beaucoup. Monsieur Généreux.
Mr. Généreux, you have the floor. Thank you, Chair. With a wonderful name like José Thibault, I think I'll present in French. Well, I'm more comfortable in English, but no problem. Okay, well, let's try. Excuse my ignorance, but CRTC, while the television and is a space within, no, we are an independent commission. The mandate, of course, is connected to the CRTC, but we are totally independent. How are you financed then? Through the CRTC or not at all? We're independent. We're funded by the industry, and each company or provider that is registered with us will provide it funding. Are you not then in a certain conflict of interest as you're being funded by your membership or your clients, as it were? So there's kind of a conflict? No, not at all, because we invoice them. Our clients, providers, have to go to the CRTC if the problems occur. So I can't give you an opinion as to what happens before the CRTC or what they might do with any kind of complaint on the part of the provider. It's funded by the sector, the industry itself, rather than where the complaints come from. It's a situation where we do cost recovery from the industry. The complaints come from within that sector, and that's what we deal with. You said 80-some% or 17% of 5,000 is that's a lot of complaints. How many complaints do you get in a year? Last year, we dealt with approximately 13,000 complaints. Actually, the CRTC is the last recourse, or we are the last recourse, in fact. If someone insists to come and table a complaint with us, but most Canadians will go to the CRTC first and then perhaps to us, 17%. So the percentage of complaints from consumers internet consumers concerns the quality of service. So just a slight detail or nuance. We deal with wired, wireless, and television complaints. Anything we get from internet complaints is, in fact, the quality of the service. And if this bill were to be adopted, do you think you'd get more complaints, given that this would provide a lot of transparency? It's very difficult to call. The number of complaints that we receive depend on a great number of factors. And I don't know if this would generate more complaints or not. These measures have as an objective that consumers get the correct information, the reliable information as to what they are getting as a service. Well, 13,000, that's at 17%, that's over 2,000 just for the quality of service. So how do you process these in Transport Canada? It takes years and years to deal with any number of complaints. Is that the same thing with your organization? No. The majority of them are resolved. I didn't quite catch the beginning of your sentence. Our resolution rate is 7 out of 10 to the satisfaction of the consumer. And the majority of these are resolved within 30 days. I heard the amount $5,000 a while ago. Is that a penalty that? No. It's not a penalty for the company. It's a compensation or indemnity to the consumer. We can oblige the telecom provider to pay back or refund up to $5,000. So you've had a complaint, the company 9 out of 10, 7 out of 10. In any case, there's no compensation necessarily in those cases. No, it doesn't mean that 9 times out of 10 they are compensated. It means it was resolved to the satisfaction of the consumer. Sometimes it's just a correct an invoicing mistake or error. It's not a compensation. It's a correction of an error, if you will, a billing error. Well, among the group of your clients, these telecoms, are some, you can't give away private information, but are some more guilty than others, in quotes? No, they're not the service providers. Those are not our clients. Our clients are the consumer, rank and file Canadian consumers who have had a situation or a problem with these telecom providers. We will arrive at a conclusion and we can decide what would be a potential resolution to the situation, and that's our role. We're the go-between. Okay, I'll reframe my question. Who's the bad kid on the block there? There's 4 or 5 major players. I know you probably don't want to identify them, but well, the major service providers have the greater number of complaints. It's not brain surgery. If you take a look at the scale, well, the size of the company, more complaints. What can you say? And they all get a fair representative percentage. And the rural or remote area are more likely to have a complaint or a problem than urban world because even though they're fewer in number, perhaps it's more significant. Well, no, there's not a greater number from rural than urban, but if we take a look at overall, all the complaints that we get that end up at CRTC, 17% perhaps come from the rural area. But when we look at internet alone, concerning the quality of the internet, that goes up to 20%. Open Media is an independent, autonomous organization. You're not linked to any particular telecom?
A grassroots community-led organization, explicitly nonpartisan and explicitly not linked to any industry player.
Votre indépendance est totale.
And you are absolutely autonomous, a standalone, arm's length organization.
Organization that's led by our community members primarily. If you're asking as to like our relationships with our funders, et cetera, I'm happy to follow up with you directly, but it's not really my area of expertise.
Non, je suis pas inquiet.
No, I'm not worried in the least. That's fine. I just wanted the information. And I'm almost finished, Mr. Chair. I think you should be involved in politics, Ms. Knight.
Oui, merci, Monsieur Généreux.
Thank you, Mr. Généreux. Mr. Fillmore, 5 minutes, please.
Thanks, Chair, and thank you for the illuminating discussion so far. I want to focus in my questions on the costs to consumers, the fees that they're paying. And to start with, I want to go back on some clarification. Ms. Thibault, you mentioned in response to an earlier question that that you are able to go back as a result of a complaint and adjust the bill, basically, of a consumer. And I wanted to know if that was kind of a one bill only thing, so you fix it for that 1 month where the consumer had a complaint, or does it actually adjust the bill in perpetuity to reflect the actual service that consumer is receiving?
So it depends on the circumstances, but in the case where, again, a customer is on a plan that provides them, up to 100, they're getting regularly up to 25, and we find, well, hey, there's actually a plan available from this provider that's an up to 50, we will require that provider usually to compensate the customer for the difference between those two plans for the months that the customer was paying for them. So if it was for 10 months, it's for 10 months. And we would propose to the customer to consider on a going forward basis to go down to the 50 megabits plan if that's more suitable to them. And of course, it's up to the customer to decide whether they wish to do that or not.
Okay, so it's looking backward, in other words, not forward. Okay, that's fine. So the example that comes to mind is, I think all of us pay an electricity bill in our homes, and we pay for the power at the rate at which we consume it. The little wheel doesn't do it now in electronic things, but the old meters used to spin around. You could see how much power you were using, and you knew your bill was going to go up because the thing was going fast. And right now, I think when we look at plans, say my plan is 100 megabytes per second, it's $100 a month. The provider is placing a value on that higher speed because the 50 megabit per second rate is $50, so obviously that's worth less. Yet consumers are paying the highest rate and getting a much lower speed product, right? They're consuming at a lower rate, and so they should be paying less. So that's like it's almost like a pay-as-you-go model, perhaps. I wonder how the witnesses today would respond to that kind of a system. And then I was hoping to draw a comparison between that kind of option versus something that I don't see explicitly in the bill as it's drafted now, but a guaranteed minimum speed. So having the big bold-faced number that you think you're getting is actually the minimum speed, and you'll pay for that. And if you don't get that speed, then there would be a reduction in price. So two different ways of looking at consumers actually paying for what they're getting. Love to hear your response to that, and if you feel there's room for amendments in this bill to accommodate either of those. Why don't we start with who? I don't know, anybody at all, because I think it's all your perspectives are important.
The minimum speeds would be easy to incorporate into this. So
in such a way that the bill would be adjusted downward when those speeds were not provided.
No, you could have minimum and then advertised, so they're not the same thing, because the speeds vary, right? It's a dynamic. It's not like electricity that's coming that you're being charged for a volume. The electricity model you used, telecom providers would love nothing better than using that kind of metered billing. And they were doing that before, but now with competition, we are towards unlimited. So you're not paying for the volume of what you're using like you do with electricity. You're paying for the size of the pipe, which is the bandwidth of your speed plan. So it's a different market in that sense.
Even
right?
if the pipe is half
So-
empty half the time. So I understand. Now, do you think that in that model that if the minimum advertised speed was not reached on an average basis, that it would be incumbent on the provider to lower the bill for that month? Like there would be a downward adjustment? What happens in other countries, other jurisdictions?
They have different approaches towards. Some countries they have the regulator, like the CRTC. Like in Germany, they have kept the power themselves. So the regulate, like the CRTC of Germany, deals with the complaints both at an individual level and also moving towards systematic fines when it's not happening in a systematic manner, because individual cases don't really incentivize bad actors to do better. Because they are very small fines, essentially. So sometimes you might have to go towards more monetary penalties. And some other countries, they have a system like us where essentially the regulators has outsourced enforcement and compliance with the codes of conduct to a third-party organization. And some countries, the competition authorities deal with this, so it's not the telecom regulator directly.
Thank you very much for that. Ms. Knight, do you have any reflections on this line of questioning and how we might better tie fee to service for consumers?
That's a really good question. And so as a consumer advocate, what I would say to that is just that the more that we can do legislatively to allow people to get more affordable services, get money back in their pocket, people are going to be in favor of those things. What I will say is that I don't know if this bill is the place to do it. It seems like it might be needlessly complicating something that is, again, fairly uncontroversial, fairly simple to do. I might break those two apart, but like I would never say like don't go after something that's going to help Canadians.
Okay. And CCTS, anything from you on this?
Well, I'm looking at the bill and it's quite clear. You're asking the CRTC to require. You're asking the service providers make metrics available around service quality during peak periods, whatever that means. Typical download and upload speeds during peak periods. So that's all very simple and plain and clear. And then any other information that the CRTC thinks is in the public interest, which gives a lot of scope for the CRTC to do what it thinks is best. And my sense is that the CRTC is the place that has the technical expertise on this. I recognize that there are many who are uncomfortable with the approach that the CRTC has taken in the past. I don't have any opinion on that, but I do think that that's the place where the technical expertise on this lies, and they have the option to hear from consumer groups and from industry at the same time, so that an appropriate review of the evidence and the policy can be had. And I think I would caution against overcomplicating this bill.
Okay, I understand. If we do wind up in a kind of minimum advertised speed situation, what happens then when that speed is not reached? What do you think the policy regimen should be? Because I mean, if we just change the way that the plans are advertised and people understand better what they're paying for, but when the promised speed is still not reached, it feels like there should be a automatic monthly downward adjustment to the bill so that it doesn't have to go through the complex appeal and complaint process. Do you think there's room in the bill for that? Or is this needlessly complicating things?
Yeah, that's something that CRTC can figure out, the implementation of it. So the key the problem is that the transparency, as you mentioned, goes only so far, right? So if whatever the target you have, it's advertised or minimum, the verification process has to be set up. For example, for the CCTS to validate a complaint, it can have a rule, or CRTC can impose it, or CCTS can come up with it themselves, that you have to show that this is your contract that says 100 megabits. You've done 10 tests. One of them shows 100 megabits and 9 of them show 50. does that constitute a violation of your contract? But those standards can be created later on.
Okay, my time is. I think the chair might give me 30 seconds if anybody wanted a final remark.
I was just going to say that I admire your creativity here and your desire to make sure that that we capture all the requirements that are needed here. I think, as I say, I think we should be careful about, and I urge you to be careful about overcomplicating this. And I think the details should be left to the detail people.
Okay. Thanks very much.
Thank you very much, Mr. Fillmore. Monsieur Lemire, la parole est à vous.
Monsieur le Président.
Thank you, Chair. My questions will go from Ms. Thibault or Mr. Maker. Among the complaints that you receive, I imagine that many are resolved because the equipment that the consumer has might, in fact, be the cause of a slowdown, underperformance in speed. Do you get that kind of situation where the speed is, as provided, is okay, but the modem that the consumer is using is perhaps at fault? So the flaw, I guess, is on the consumer end and not on the provider end.
Complicating factor. There's no question that a customer's equipment can impact the speeds they're receiving, and the way their network is configured can have an impact on that. That's a challenge for us, I would say, because we don't have very good visibility into what the consumer is running in their premises. I mean, we can ask the questions, but it's pretty hard. We don't have a team of engineers to go out and measure speeds at customer premises.
Mais est-ce qu'à ce moment-là...
Well, in that case, would the company not provide them the equipment to ensure that the speeds are met, be it their telephone or their internet connection, modem? It should be part of the chain.
We do when we get a complaint is make sure that the service provider has engaged in troubleshooting. So that's not just about their own facilities, but that's helping the customer figure out, okay, so what modem do you have? How old is your modem? How far is your modem, to your equipment? Like, are you using it? Are you plugged in, or are you using it over Wi-Fi? And our expectation is that service providers are going to work with their customers in order to figure that out. In many of the models we see, service providers, when they provide internet service, they also provide the equipment. And so there's an obligation there to also look into that and make sure that equipment is appropriate in those circumstances.
Et est-ce que dans l'ensemble...
Well, overall, are there problems that can be resolving themselves in a way? What percentage of problems is due to the consumer equipment rather than the connection being offered by the provider? Well, I don't have data on that. There are situations, of course, where the resolution of the complaint can be resolved by simply upgrading the equipment or switching it. But that's an agreement that has to be reached by the provider and the consumer. The quality of service could be resolved that way. In other cases, unfortunately, it's not the case, but I don't have enough information on that. Thank you, and your French is terrific, so thank you. Thank you very much. Mr. Massé.
Interesting point that hasn't been raised before in actually all of our telecom studies. And I want to follow up with that, Ms. Thibault, on that. And that's the equipment issue, because I've been through it myself where, it's not working right. And by the way, your telco provider doesn't tell you you need a new modem. Oh, I found out my modem was like 5 years old and hadn't been updated in software or whatever, didn't do the right download it was supposed to and so forth. There was no notification. I just kept on paying and assuming it. Is there a lot of this happening? Because obviously it became a problem is why we started raising the issue. But it would seem by that, though, it's almost to the advantage of the provider at that point, is me to suffer with that service, not get as best as I could. In the meantime, they don't have to replace my equipment, and they also can actually expand to other speeds elsewhere. I mean, it's, I'm just wondering whether there's something on the consumer advocacy front we have to do for them to notify people about equipment updates as well.
Yeah, so again, I don't have statistics I can share with you about that. What I can say is that it is very common for service providers to take a look at the customer equipment when they are troubleshooting issues. That's been our experience, and when we're working with complaints, that is our expectation, and we follow up on that, and we'll get reports on what was found. So that's what I can tell you. That's what I can speak to. The rest of it, I feel is a little bit more about, informing consumers of their rights. And again, we're always big proponents in making sure that consumers are educated as possible and understand how to navigate the system.
Okay, thank you. Quickly to Ms. Knight, do you think that's maybe a thing that we should be looking at in terms of at least a responsibility to notify customers at a time when they actually upgrade equipment, and if you're eligible for that? I've only found out by accident.
I can say that I wish that my ISP would tell me that information personally. So yeah, I mean, like that falls under a lot of what we've talked about today, where there are a lot of great ideas are coming out as to how we can help empower consumers to, actually get what they pay for, have good quality service in ways that are currently not protected. So absolutely, like we can explore all of these ideas. I don't think that this bill is the place for that, but like I would never shut that down. I think that's a great idea.
Thank you, and thank you, the witnesses. Thank you, Mr. Chair.
Thank you very much, Mr. Massé. So that concludes our official rounds of questions, but given that we have more time, I will open the floor to anyone who wants to ask questions. So Mr. Perkins.
Thank you, Mr. Chair. I just have a couple more questions. I won't prolong the meeting too much. The sponsor of the bill, Mr. Mazur, who's here today, in his opening talked about that where this has been implemented, I think primarily Europe, complaints have actually gone down to the regulatory bodies there. So I wonder, Mr. Maker, if you've got or seen any data on that?
I have not seen any data on what's going on in other countries that have done this. And it seems that complaint environment is different in different countries. And so I would hesitate to draw any direct comparisons. But that's the objective here, right? The objective is to try and reduce the number of complaints. Because customers are informed about what they're getting and they have nothing to complain about. Now, we don't live in nirvana. We know that there's always going to be problems, and sometimes there's the opposite effect where providing disclosure makes customers actually understand what they're not getting. And so it's really very difficult to predict what will happen in terms of complaint numbers. But we're hopeful that something like this would cause them to go down.
Maybe to Ms. Knight, the same question. I don't know if you have access to any or are aware of that at all.
I don't think I'm the best to speak on that. If you want me to speak on like how our community responds to this type of thing, yes, like we've heard, we've had a wider conversation with our community for, I would say, more than a decade about this type of issue through several iterations of Parliament about the unfair power that big telecom has over people in Canada. And so when we hear like this service quality sentiment from our community, it's often embedded within a wider conversation about things like the Roger Shaw merger, like people dislike that. And some of the reasons that they give for that are that these big companies already abuse us. These big companies already hurt us. So why would we want them to get even bigger? So that's the kind of thing that we hear from our community. And I don't have stats for you to share, but yeah, I'm always happy to report more on what our community thinks about this type of thing.
I appreciate it. Just one more question, Dr. Rajabin. There is been expressed a concern that if you say that it's possible to have a regulated minimum speed within these packages, that the companies will, unless you're very specific, will just use 0 as the minimum speed like they do now. What would be your suggestion about how we either through this bill or any other mechanism make sure that that doesn't happen?
The CRTC has already established a 50 millisecond minimum service quality standard that it's not implemented. but they have established it. So that minimum needs to be low. It cannot be too high, right? Because the speeds are going to vary. So you could set a minimum, let's say if it's 5, you can have a baseline for what you want that minimum to be. For example, the 5010 basic service standard that is part of the universal access process says that's supposed to be a speed, a capacity that's enough for a household with multiple people to be running multiple applications at the same time. That's why this CRTC adopted it. So, but people are adopting higher speed packages because they really cannot use this services they need for something at 5010. So a much lower minimum around that enables people to use basic service, very basic service, say at 5 megabits per second up and down. That can be a standard that can be used, something like that.
So, Ms. Knight, sorry, I am going to back up and say I've got one more question, even though the last one was the last question. Was that on that minimum speed issue, and I think in your submission you actually had 3, 5, 10. Is that meaningful, having a minimum standard that low, especially when some of the packages are, offering as high as, or saying that they're going to offer as high as 8 gigabytes per second, to say that 10 is an adequate minimum?
So I don't think I can tell you what the adequate minimum should be. When I think about service quality standards in Canada, I'm always looking to the future, right? So we have 5010 as the speed standard in Canada that we're shooting for, but at Open Media, we always talk about future proofing. So we're looking into, let's say 50 years from now, like when does 5010 become obsolete as well, right? And so if we're looking to make sure that our communities who today are getting insufficient service, how are we looking forward to make sure that in the future we're not getting them bits and pieces, so that later on they can have the same problem and we can just kick the can down the road. So yeah, I don't think I can tell you like what a particular minimum should be, but shoot for the stars, I guess. We can look to the gold standard of connectivity in a lot of communities, which is fiber internet. We can look to public the public funding for internet infrastructure having types of technologies required. So I'm a believer that like we shouldn't be funding too much like satellite services when there are things like fiber available, and making sure those are available to communities regardless of where they live.
So just to summarize on that, the idea then that somehow there should be an annual or some other mechanism, annual or maybe even faster as technology changes, of that should be part of this process that says that whoever it is, the CRTC, the government, ISED, has to do an annual review to say technology's moved ahead, so therefore we should move to a higher level of minimum standard at some point, because just letting it sit there for 5 years is probably silly. It'll all be obsolete, as you say. Is that essentially what you're saying?
Yeah, like I'm saying, like future proofing should always be a part of figuring out any sort of minimum service standard for any reason. I don't know if that's a legislative application or that's a regulatory thing, but yeah, absolutely. It can't just be one and done forever.
Great.
Well, thank you very much, Mr. Perkins, and thanks to all of our witnesses today for sharing your time and your insights with us. Thank you also to MP Mazier for bringing this important bill forward. Et merci aux interprètes,
And thank you to the interpreters, the staff, researchers. Thank you very much, and have a good end of the day.